Okay, AI and employment law, and specifically employment contracts. So, for those of you that are new to AI or completely new, relatively new, I'm going to just walk you through what you're seeing on my screen. So, on the right hand side, you'll see this is ChatGPT. I'm sure you've all heard of this. You can get, of course, a free version, but I do not recommend it. First of all, it's not as good. So the output and ability is really, really low compared to the paid version. And also it is not secure. So you've all heard of ChatGPT being able to take data from one input and then it stores it in its memory and it uses it elsewhere. That is the free version. Make sure that you pay and get the premium versions or team versions, and always check your security settings. Some of the higher paid ones are automatically set so that they are not sharing, they are not learning from your data, and others you have to automatically set yourself. So do your due diligence there. This, of course, is the paid version, so I'm just going to show you a little bit about how we can use ChatGPT, converse with it in this window, upload documents, and ask it to help us analyze complicated employment contracts to flag any issues as we're going through. So as you'll see, I've already actually uploaded. To upload, you would just press this plus button and then upload it from your computer, but to save time, I've already uploaded it. And on my left-hand side of my screen, you're going to see an employment agreement. This is just a fake employment agreement. Actually, I had AI help me produce this. You'll see it's pretty standard. We're looking at Ontario, so we've got position and duties, we've got compensation, probationary period, confidentiality, non-compete and non-solicitation, termination clause, and then some general provisions at the end, and of course a place to be signed. So all of this is fine. So imagining that I'm setting out to review this for my client who perhaps is the employer, and I want AI to help me with some of that efficiently. So I've prepared this prompt already for the sake of time. So it says, I'm an employment lawyer in Ontario. Please review this employment contract and identify any clauses that may be unenforceable or problematic under Ontario law. Focus on termination provisions, restrictive covenants, and any areas where the contract language doesn't align with how courts actually interpret these issues. So it's a pretty big task for a robot. Let's see how it does. It's going to be taking a look. It's going to review the contract. And here we go. So it's going to flag the issues based on how Ontario court or plaintiff's counsel would. First of all, we've got the termination provision, so there's a high risk of being set aside. So good, it's found my first issue, which is that the termination without cause provisions. It says notice of termination, pay in lieu of, and any applicable severance pay in accordance with the minimum requirements of the Employment Standards Act. So then it tells you the problem. The clause limits entitlements to ESA minimums, but it does not expressly confirm that all ESA entitlements will be met in every circumstance. So it's flagging some of these issues that you're going to want to look at. Likely result clause is unenforceable. It's also telling us that the termination for cause provisions, and I can just scroll down on my screen here so you can see it, are also likely not valid because, of course, for cause termination is talking about dishonesty, breach of material term of the agreement, unsatisfactory job performance, and so we all should know as employment lawyers that those are very much beyond the scope of the ESA. So it's flagged that for us as well. It's talked about a probation clause issue likely being ineffective. We're talking here within the first 3 months of termination with 1 week's notice, which is not required by the ESA, so it's flagged that. It's also talked about, of course, restrictive covenants and non-compete clauses likely unenforceable now in Ontario. It goes on, of course, it's finding me lots of other things. So as a follow-up prompt, what we might want to do, because of course, you would never take the first output from ChatGPT or any AI tool. I don't think that would ever be good enough. You're going to want to iterate with it and dig in a little bit, use your own lawyer brain, which it does not have, to be a little bit more analytical or question issues. So what you might say is, okay, for the non-compete competition clause specifically, what's the current state of the law in Ontario regarding enforceability for non-executive employees? I might say add cites to your sources. Just so that we can follow them through ourselves, look at websites, and figure out and inquire further. So it's thinking longer for a better answer. This is normal. Sometimes that's good. It's doing a little bit more analysis, which will give you better output. So we can see here that the AI has brought back more information. It's done a thorough research. It thought for a minute and 12 seconds. It tells you that. It shows you of course, all the places that it's looked as well, which you can review. It's also got links to the site, so you could click on this and it would take you to the Employment Standards Act. You could review the provision for yourself. Of course, you should. But it's giving you a really nice highlight and summary, which you're going to fact check and confirm. It does pull from Canly. It also pulls from legal blogs. Sometimes those are right, sometimes they're wrong. So always do your due diligence. But it's a really nice high-level review of everything so that you can dig into it more yourself. And then, of course, it's going to tell you the current state. So as a final follow-up, what I might do is just ask it a little bit more about the probationary clause, just so you can see another prompt sample. So does the probationary period clause actually limit the employee's common law notice entitlements? What would a court look at? So again, I'm asking it to think a little bit like a judge, and it's going to give me a pretty quick answer. Short answer, usually no, and Ontario courts are pretty strict about this. So then it's going to give me, again, an overview. Okay, we've got the starting point. Probation does not automatically displace common law notice. It's giving me some helpful information about that. This is interesting here. You'll see courts repeat this point often. Okay, well, where does that come from? So again, if I had more time, I'd probably show you more of my iteration process. I'd probably dig in and say, well, where'd you get this quote? Show me a site, what court, what case? Maybe I can look it up myself. Sometimes it can't pull the direct case. It can pull references to it, but it can give me the site, and then I can go on Canly and look it up myself and read it. That would be really helpful, particularly if I'm writing a demand letter or if I'm giving advice back to my client. I want to look at the potential case that I want to rely on, and I want to make sure that I'm citing it properly and paraphrasing it if that's indeed the case. So it's going to give me all of this very good information. So that's really helpful. So as a final point, one thing that I want to show you is what you might do with this once you, of course, have done your due diligence, read it, reviewed it, agree with the information. Of course, you can iterate back and forth as many times as you want, right? Hey, you got this point wrong. I found this case. Redo that part of the analysis and tell me what you think now. So you can play with it a little bit and be the lawyer, of course, in this role. But it's a fast track way to get through a lot of complicated documents and also pick up things sometimes you might not notice. Sure, like I would always flag the termination clause, but maybe I wouldn't have noticed the probation on my first glance. So, if that's just an example, there might be other little things that it notices, like a date is wrong or, something to do with the duties might be elaborate or unclear or not part of a role that would be typically, for example, a manager. So sometimes it's going to highlight things for you that you may have not caught. So that's a really good first step. And so as a final thing, what I might want to do is once I'm very confident in the analysis and I've done my review with it, I may want to then send an email to my client with some advice. So I may want its help with that. So in order to do that, I would give it some sort of prompt like this. Now draft a plain language email to my client explaining the 3 issues we identified. Keep it professional but accessible. Avoid legal jargon where possible. The tone should be reassuring but clear that these clauses need attention before they sign. And I may add something like, and refer to law, both statute and cases where relevant to help them understand where the advice is coming from, or something to that effect. I'd probably go more in detail. The one big pointer that you should leave with today is that your prompts, which are basically the way you communicate with AI, are everything. If you give it a really good, long, detailed, contextual prompt, you're going to get way better output and save yourself time and also just have better product at the end of it. So I'm going to ask it to draft this. This is really helpful. Again, probably not your first pass is going to be the one you use. Sometimes it is, especially again, if you have a really good prompt, but it's gonna help me. So thanks for sending the employment contract through. I've reviewed it carefully and overall it's a fairly standard agreement, but there are 3 clauses that raise concerns. And so it's gonna raise it for you. Termination clause, what happens if your employment ends. So it's being very specific, it's helpful, it's explaining these provisions, what they mean. It's referring to the statute like I asked it to. Non-competition clauses, so again, it's giving you this, okay, major red flag, this is where we're concerned, we're having to give advice about this. This clause is very unlikely to be enforceable. Probationary period clause, and of course next steps. None of this means you should panic. Again, you may want to change some of this language, totally fine. So you can either cut and paste this, put it in your email client, edit, revise, add, change, or you can iterate with it again and say, okay, I like this, I don't like this tone, I don't like this word. I think you also need to add a whole statement about, federal versus provincial jurisdiction because I'm a little concerned. about that and which one they might be regulated by. All kinds of things, right? You can iterate back and forth until you get a good product, or you can take it offline and do it yourself. The choice is yours, and I think it also depends on the complexity of the task you're doing and how good and on point your AI is. Not all AI tools are created the same, and of course, at the end of the day, you're the expert, so don't forget that. Hope this helps.